Meeting to order. Welcome to meeting number 12 of the House Commons Standing Committee on Justice and Human Rights. But for the first panel, we have with us from the African Nova Scotian Justice Institute, Derico Simons, le directeur des initiatives en matière d'engagement et de justice,
Director Justice Initiatives, who is here by video conference.
Constitution Foundation, Christine Van Geyn, directrice du contentieux. De la Ligue des droits et
Litigation
libertés,
Director.
Lucia Flores Echaïz, avocate. Merci, bonjour.
Lucia Flores Echaïz, lawyer, thank you.
Porte-parole.
Linda Khalil, spokesperson, and finally from the Canadian Bar Association, once again by video conference, Kyla Lee, lawyer. And I would remind the witnesses that we have to be strict on this. You have 5 minutes each for your opening remarks, after which we will proceed, of course, with the questions from committee members. So, welcome. Without further ado, I'll give the floor to Mr. Derico Simons for 5 minutes.
You have 5 minutes.
Derico.
Thank you. Thank you, Chair and committee members, for the opportunity to speak today. My name is Derico Simons, an eighth-generation African Nova Scotian and Director of Engagement and Justice Initiatives at the African Nova Scotian Justice Institute, or ANSJI, rooted in Nova Scotia. Established to confront systemic injustice and anti-Black racism, ANSJI advances justice reform, supports victims of hate and discrimination, and promotes equitable, inclusive institutions and safe communities across Nova Scotia and Canada. We recognize Bill C-9, the Combating Hate Act, as an important step towards updating the criminal code to better protect vulnerable communities. It acknowledges the rise in hate crimes and the need for stronger legal protection, yet the bill's current framework is too narrow. I want to draw attention to major gaps for Black Canadians. Its terrorism-centric approach to hate symbols. The bill omits the noose, one of the most recognized symbols of anti-Black terror. The noose evokes centuries of racial violence and continues to appear today in schools, workplaces, and public institutions used to intimidate and silence Black Canadians. Additionally, it is our belief the Ku Klux Klan, or the KKK, also meets the criminal code definition of a terrorist entity. Its actions, lynchings, bombings, cross burnings were designed to intimidate the public through violence motivated by white supremacist ideology. Its influence continues to surface in extremist movements and hate crimes today. Excluding the KKK while listing its ideological successors creates a gap that undermines both moral and legal coherence. Recent incidents in Nova Scotia show this hate is not history but reality. 2024, individuals wore KKK costumes at a Halloween gathering in Cape Breton, Nova Scotia. 23, 2 teenagers in Chester Basin, Nova Scotia were charged after waving a noose at a Black family. 2020, a sign reading Redneck Hangout with a noose was found in Queens County, Nova Scotia. 2019, footage I observed documented KKK recruitment activity occurring at a Halifax, Nova Scotia workplace. These are reminders from Nova Scotia that anti-Black racial terror persists in Canada. Bill C-9's consideration of amendments to remove or limit the Attorney General's signing authority in hate-related designations poses risks for Black communities. The Attorney General serves as a constitutional safeguard, ensuring that prosecutions and designations are guided by public interest and ministerial accountability. Removing this oversight would decentralize discretion to police and Crown agencies, institutions that have well-documented histories of systemic racial bias. In Nova Scotia, the Wortley Report of 2019 confirmed that Black residents were 6 times more likely than white residents to be street-checked by police. In such context, shifting unchecked discretion to frontline enforcement only could reproduce systemic harm, not prevent it. According to Justice Canada in 2022, police reported hate crimes motivated by hatred or race or ethnicity increased by 12%, whereas the percentage of hate crimes specifically targeting the Black community increased by 28%, which counts for more than double. Without AG oversight, decisions to investigate or prosecute under hate-related provisions could occur without sufficient checks and balances, risking further marginalization of communities that are already over-policed and feeling underprotected. To close, I respectfully submit 4 recommendations. First, expand the definition of prohibited hate symbols to include the noose, KKK insignia such as white pointed hood and burning cross. Second, list the KKK as a terrorist organization under Section 8305. Third, establish independent community advisory panels to work alongside Attorney General oversight. These panels can ensure that decisions about hate symbols terrorist entities, and hate-related acts are informed by those with lived experience, as well as experts and academia, and not made only and solely with government or law enforcement frameworks, conceivably something similar to the cross-cultural roundtable on security. Fourth, meaningful consultation with Black communities and organizations when developing a more inclusive list of prohibited symbols and terrorist entities. Ultimately, a meaningful Combating Hate Act must confront hate in all its manifestations, including the intimidation of Black Canadians that we still experience today. ANSGI looks forward to collaborating with Parliament and all parties and partners to strengthen this bill and promote genuine community safety and justice. Thank you.
Thank you, Mr. Simons. Ms. Van Geyn for 5 minutes.
Thank you, Chair, and thank you, members of the committee, for the opportunity today to appear on Bill C-9. My name is Christine Van Geyn, and I'm the Litigation Director with the Canadian Constitution Foundation, which is a nonpartisan legal charity dedicated to defending Canadians' constitutional rights and freedoms. We at the CCF have been involved in landmark free expression cases at the Supreme Court, including Whatcott and Ward. We brought the successful legal challenge to the federal government's invocation of the Emergencies Act in 2022, and we provide free public education to the public on constitutional law. I've also authored 3 books on the subject. Now, I want to be clear at the outset, hate is wrong. Hate causes real harm in society, and hateful conduct, especially violence and threats, must be confronted. But the criminal law is our most powerful state tool, and it carries the highest stigma and the most serious consequences for liberty. It must be used with great restraint, especially in matters touching expression, belief, and political or religious discourse. Bill C-9 expands the criminal law into the realm of expression in ways that risk unjustified violations of the Charter right to free expression. It lowers the threshold for hate propaganda offenses, removes safeguards against politicized or abusive prosecutions, introduces vague new offenses, and risks chilling lawful debate and protest in Canada. Our constitutional tradition is clear. Freedom of expression protects even offensive and disturbing speech, and even hateful views, unless they cross a very high threshold. Courts have always treated this as a question of where limits on protected speech exist, not on whether the speech is protected at all. That high threshold exists so Canadians can freely discuss controversial ideas, especially on sensitive political and moral topics, without fearing criminal sanction. Bill C-9 lowers that threshold and expands criminal liability in ways that threaten legitimate expression, dissent, and protest. Our primary recommendation is that Parliament withdraw Bill C-9. In the alternative, I propose 6 amendments that could reduce, though not eliminate, the risk that C-9 would be found to be unconstitutional. First, the bill introduces a new statutory definition of hatred that departs from the Supreme Court's jurisprudence. For over 30 years, the court has required hatred to mean the emotion of an intense and extreme nature that is clearly associated with vilification and detestation. Bill C-9 dilutes that standard. It removes key limiting language and shifts from detestation and vilification to detestation or vilification. It removes the requirement for extremeness. So if Parliament chooses to legislate a definition, it must mirror exactly the standard that has already been upheld by the court, because anything less risks a finding of unconstitutionality. Second, the bill removes the requirement for Attorney General consent before laying hate propaganda charges. That safeguard exists to prevent politically motivated or ideologically driven prosecutions in this uniquely sensitive area of law, and removing it invites arbitrary or inconsistent enforcement and even opens the door, however rare, to private prosecutions weaponized for political ends. Third, the bill creates a new standalone offense for hate crime offenses layered on top of other existing offenses, including non-criminal regulatory offenses. This creates a risk of duplicate punishment, prosecutorial overcharging, and plea pressure. Hatred is already a sentencing aggravating factor, and that approach preserves proportionality while protecting freedom of expression, so it should remain that way. Fourth, the bill prohibits hate symbols. Now, to be clear, these symbols are vile, but banning them outright risks driving hateful beliefs underground where they are harder to confront, and risks sweeping in political protest speech, however misguided or offensive. The current law already captures symbols when they are used to willfully promote hatred. Fifth, the bill adds a new intimidation provision related to religious and cultural spaces, but intimidation, harassment, mischief, and blocking access to buildings is already illegal. The solution to unlawful blockades is to enforce existing law. And finally, we urge Parliament to retain the defenses in Section 319, sub 3, including the defense of good faith religious expression, because removing that protection, combined with removing Attorney General consent, would chill legitimate religious debate and moral discussion. Courts have already applied that defense narrowly. It has never been successfully invoked, but its existence has been central to the court's conclusion that the law is constitutional as it is. Hate cannot be legislated out of the human heart. What the criminal law can do and what it should do is prevent violence, threats, harassment, and intimidation. But when we criminalize opinions, we risk making martyrs out of hate mongers and driving vulnerable people towards hidden spaces of radicalization rather than exposing harmful ideas to the disinfecting force of truth and public criticism.
Ms. Van Geyn, if you could sum up.
Yes, I'm done. So thank you, and I welcome your questions.
Thank you. Maintenant, pour la Ligue des droits et libertés, Mesdames Flores, Séchaïs et Khalil, 5 minutes à partager entre vous. Merci.
Président, bon après-midi aux membres et personnel du comité. Ma collègue et moi vous remercions de l'opportunité de partager le point de vue de la Ligue des droits et libertés sur le projet de loi C9. La Ligue des droits et libertés est une organisation indépendante et non partisane fondée au Québec en 1963, qui vise à défendre et à promouvoir les droits humains.
Un instant, Mme Flores-Séchaïs.
Et la traduction en français, elle était terrible. C'était écho et saccadé. Je n'arrivais pas à suivre ce qui se disait en français. Et là, il n'y a pas de traduction en anglais, donc il y a un problème manifestement. Là.
On va suspendre 2 secondes pour... espérons que c'est 2 secondes, mais pour, aucun problème. No, it's the same in English, yeah. Pardon, problème de traduction. Ce n'est pas de votre faute, là, mais on va s'arranger.
Hi, John. It's Ricky from IT. Could you speak to me on the English?
annoncé au projet de loi, étant donné que ces lieux constituent aussi des milieux de travail. Les nouvelles infractions risquent de pénaliser démesurément les travailleurs et travailleuses qui y œuvrent. Par ailleurs, mentionnons que des manifestations peuvent avoir lieu devant des lieux visés par le projet de loi, non pas en raison de la nature du lieu, mais de l'événement qui s'y déroule. Compte tenu que le Code criminel offre déjà suffisamment d'outils à une personne victime d'obstruction ou d'intimidation, ces nouvelles infractions sont au mieux inutiles et au pire, ce que nous craignons, elles visent en fait la commission d'actes la criminalisation d'actes que la Charte canadienne protège. Elles auront à tout le moins l'effet de dissuader, notamment les groupes identifiables qu'on vise à protéger justement, de manifester devant certains lieux. Une telle atteinte aux libertés d'expression, de réunion pacifique et d'association est ainsi injustifiable à nos yeux. De plus, concernant la création d'une nouvelle infraction liée à la commission d'une infraction motivée par la haine, cela aurait pour effet de déstabiliser la cohérence du Code criminel qui prévoit actuellement que la haine constitue un facteur aggravant au moment de la détermination de la peine. Les peines maximales sont aussi augmentées de façon excessive, rompant avec le principe d'harmonisation des peines. Finalement, la suppression au consentement du procureur général qui est proposé dans le projet de loi ne changerait pas la pratique au Québec, mais nous considérons qu'elle réduirait le filtrage réel ailleurs au pays, augmentant ainsi le risque d'accusations mal fondées et abusées. Nous sommes disponibles pour répondre à vos questions. Merci de votre attention.
Finalement,
finally,
de l'Association du barreau canadien, Ms. Kyla Lee.
The Canadian Bar Association, Ms. Kyla Lee. You have 5 minutes.
Good afternoon, and thank you for the opportunity to appear before you today. My name is Kyla Lee, and I'm speaking on behalf of the Canadian Bar Association's Criminal Justice Section and its Sexual and Gender Diversity Alliance. The CPDA is a national association of over 40,000 lawyers, law students, notaries, and academics. Our mandate includes seeking improvements in the law and administration of justice. The Criminal Justice Section represents both Crown and Defence Counsel from across Canada, giving us a balanced perspective on criminal law reform. Bill C-9, the Combating Hate Act, addresses a deeply concerning rise in hate-motivated conduct across our communities. We support the intent of the legislation to protect historically targeted groups and to respond to the reality of hate in Canada. At the same time, we believe some provisions would benefit from clarification to ensure the bill achieves its purpose without unintended consequences for Charter-protected rights and without unintended consequences for the historically marginalized people it seeks to protect. First, the definition of hate-motivated crime offense. The definition of hatred, while defined from the Supreme Court or derived from the Supreme Court of Canada's Keekstra and Whatcott jurisprudence, becomes confusing in the bill's clarification clause. The clause states that discrediting, humiliating, or offending alone is insufficient to meet the definition. This language, when taken out of context from the case law, risks narrowing the concept in a way that will cause uncertainty in both prosecutions and defenses alike. Hate crimes inherently discredit and humiliate their victims. Clarifying that those elements are insufficient creates ambiguity rather than guidance. We recommend removing or redrafting this clause to more accurately reflect the jurisprudence. Secondly, we have concerns about the new offense of intimidation or obstruction of access to certain places. The sections agree that people must be free to access places of worship, education, and community life without fear. Our concern lies in the breadth of the proposed language. The actus reus obstruction and interference is undefined. This could encompass peaceful protest or assembly, particularly surrounding complex issues for which there is no clear political or social consensus. Section 2C of the Charter protects the right to peaceful assembly, and without clearer wording, individuals engaged in legitimate protest near such sites could face prosecution simply because their presence or expression causes discomfort. We suggest Parliament more precisely define what constitutes unlawful obstruction or interference to make it clear what conduct specifically is being addressed. Parliament should also strengthen the exemption for communicating information. Third, we have concerns regarding the provisions surrounding the display of terrorism or hate symbols. The intention to prevent glorification of hate and terror is indisputably laudable. That being said, our concern is proportionality and certainty. Only two specific symbols, the Nazi swastika and the SS bolt, are enumerated in the criminal code. Leaving the determination of other prohibited symbols to regulation is simply inadequate. This offense directly engages freedom of expression rights, and as such, fulsome parliamentary debate, study, and discussion is necessary to ensure that anything specified as a hate symbol is properly and thoroughly considered. We need look no further than our neighbors to the south to see ways in which a government's regulatory power can be misused to quash free speech. We also recommend the offense require proof the symbol was displayed for the purpose of promoting hatred. This ensures that legitimate educational, religious, or artistic displays remain protected, consistent with the bill's own defenses. The CBA sections share the government's goal of addressing hate-motivated violence and intimidation. Our suggestions aim to make these new provisions both effective and constitutionally sound, targeting conduct that spreads real harm while safeguarding the rights and freedoms that are the foundation of our democracy. Thank you. I will be pleased to answer any questions.
Thank you, and thank you to all witnesses for their opening statements. The round for the 6-minute round, we'll start with Mr. Brock, and then followed by Ms. Latanzio, and then, as usual, Mr. Fortin for 6 minutes. So, Larry, over to you.
Thank you, Chair, and thank you to all witnesses for your attendance and participation. Without limiting and without reflecting on the seriousness of this particular study, there was a decision that was released by the Supreme Court of Canada last Friday that is very disturbing on its facts and its implications moving forward for those being prosecuted with child sexual exploitation related offenses. And for that reason, I am asking for the indulgence of the witnesses while I intend on moving a motion. Mr. Chair, this motion was put on notice this past Monday, November the 3rd, 2025, in both official languages. I wish to read the motion into the record at this time. That given that the Supreme Court of Canada removed mandatory minimum sentences for offences related to child sexual exploitation and incorrectly ruled that these mandatory minimum sentences were cruel and unusual, and given that the premiers of Alberta, Saskatchewan, and Ontario, as well as the leader of the official opposition in Manitoba, have all publicly called for the use of the notwithstanding clause to overturn this decision, the committee call on the government to invoke the notwithstanding clause to reinstate these mandatory minimum sentences for child sexual exploitation, and that this be reported to the House. So, unfortunately, the decision itself is some 70 pages long, and approximately 1 page of that 70 pages is actually devoted to a description of the facts that were read into the record and accepted by the original trial judge in the finding of guilt. And I think it's important that this committee and Canadians who are watching these proceedings truly appreciate the heinous nature of the facts the Supreme Court of Canada was faced with. For the record, I am reading from paragraphs 9 and 10 of the decision. Decision is known as the Quebec Attorney General versus Senville. Paragraph 9. Louis Pierre Senville pleaded guilty to 1 count of possession of child pornography, section 163.1 sub 4 sub A, and to 1 count of accessing child pornography, section 163.1 sub 4.1 sub A. He admitted having been in possession of 475 files, including 317 images of children constituting child pornography. Of those images, 90% were of young girls between 3 and 6 years of age, some showing victims being subjected to acts of penetration and sodomy committed by adults and minors. Mr. Senville admitted that he had acquired these images through specialized sites and that he had possessed them for 8 months. He accessed these images for 13 months. Mr. Senville is a former soldier who was 28 years old and had no criminal record at the time of the sentencing decision. The decision noted that he cooperated with the authorities and complied with strict release conditions. Paragraph 10. Matthew No pleaded guilty to 1 count of possession of child pornography and to 1 count of distribution of child pornography. He admitted having been in possession for 13 months of 531 images and 274 videos of child pornography, most of which were of children from 5 to 10 years of age being subjected to sexual abuse, such as fellatio and vaginal and anal penetration by adults. Mr. No used specialized software to access that material, make it available, and wipe out any traces of it. Now, this decision, Mr. Chair, was released last Friday. From last Friday until earlier this week, there was absolute deafening silence from the Liberal government, particularly Prime Minister Carney and his Justice Minister, Sean Fraser. In fact, Mr. Carney, Prime Minister Mr. Carney, was very active on his social media over the weekend, including last Friday, highlighting all the photo ops of he in Asia on his trip, and not one mention of a decision that has rocked this nation. Justice Fraser, absolutely nothing until confronted in the House by opposition members asking for his immediate use of the notwithstanding clause. Now, we've heard, as I've indicated through the nature of the motion, how various premiers and other leaders have reacted. Now, to be fair to Sean Fraser's office, there was a spokesperson who did utter a statement on Friday denouncing child abuse and exploitation generally. The statement remained non-committal on whether the federal government intended to challenge the ruling. However, in Justice Fraser's home province of Nova Scotia, the provincial AG and Justice Minister Scott Armstrong issued a blunt rebuke on Saturday, calling the judgment deeply troubling and demanding action. He stated, "Nova Scotians should be able to expect that sentences for those who commit horrible crimes will protect the public and not leave victims feeling more vulnerable," Armstrong said in an official government statement released on Saturday. He says, "This ruling raises serious questions about whether the punishments will truly reflect the severity of those offenses and the pain they inflict. Mandatory minimum sentences send a clear message that exploiting children is among the most serious crimes and will be treated that way." Armstrong added that he would share his grave concerns with Fraser and urge Ottawa to take action to ensure our justice system continues to protect the most vulnerable, particularly children and youth. Alberta Premier Daniel Smith, Ontario Premier Doug Ford, and federal Conservative leader Pierre Poilievre each condemned the decision in separate posts on X. "This decision is outrageous," said Premier Smith in an X post shortly after the Supreme Court's decision was rendered and made public. "The possession of child pornography is a heinous crime, and even a 1-year minimum sentence is already far too lenient." Smith says she is calling on the federal government to immediately invoke the Constitution's notwithstanding clause to overturn this ruling and ensure the protection of our children. In an ex-post similarly timed to Smith's, Ontario Premier Doug Ford said, "I can't believe it. the Supreme Court ruled against 1-year mandatory minimum sentences for the possession and access to child pornography. Like Smith, Ford also called for the federal government to intervene, saying that the notwithstanding clause was designed to protect the will of the people, before demanding that the federal government overturn this decision immediately. Pierre Poilievre went further, pledging legislative action if elected and calling the court's decision dead wrong. Child porn users must face mandatory prison time. The Supreme Court ruling today removing those penalties was dead wrong. The opposition leader wrote on Friday before promising that a future Conservative government would use the notwithstanding clause to protect the rights of children by locking up child porn users with mandatory prison time. In today's one of today's papers, there was a heading in a story that says, "Sean's gone wrong. Use notwithstanding clause in wacky child porn ruling." If there ever was a court ruling calling for the use of the notwithstanding clause, it's the debacle issued by the courts last Friday. Yet the Carney Liberals are saying that they won't overturn that politically motivated and poorly thought out decision. Justice Minister Fraser was asked about using Section 33 of the Charter to override the court several times on Tuesday and said no, he wouldn't do it. In a shocking 5-4 decision last week, the majority ruled that the mandatory minimum sentence of 1 year was cruel and unusual punishment and a violation of the Charter. They did so not by ruling on the case before them, and I highlight the facts that I read out, but inventing a new possible case to arrive at their politically motivated conclusion. Justice Mary Morrow, who released the majority decision, invented the reasonable hypothetical of a 17-year-old girl texting a nude image of herself to her 18-year-old boyfriend, who then shared it with another 18-year-old who held on to it for a while instead of just deleting it. Morrow said in this case, a 1-year mandatory minimum sentence for possession of child pornography would be cruel and unusual and violate Section 12 of the Charter. Therefore, she ruled that the mandatory minimum had to be struck down in all cases. The ruling, starting with the made-up reasonable hypothetical, is insane. No prosecutor is going to bring those charges in the made-up case that Morrow used to justify her actions. I'm going to pause right there, Mr. Chair, and remind this committee that I enjoyed a almost 2-decade career as a Crown prosecutor, and I can inform you what the Supreme Court of Canada didn't touch at all is the use of discretion. The scenario, the unrealistic scenario that Justice Morneau used in that decision, in my view, would never see the light of day in any criminal court. Police have discretion. They are the first line of intervention when matters are brought as a potential breach of our criminal code. In the circumstances before them, I can't imagine, as a former prosecutor, any police service charging this particular individual with 1 count of possession of child exploitation material. There are other charges available to the police service in those circumstances, but even if the police service of jurisdiction had decided to lay a charge and bring it to my attention or any Crown attorney in this country, I doubt very much we would exercise the discretion to immediately, because it's a hybrid offense, to immediately proceed to prosecute by indictment seeking a minimum 1-year penalty. It is ridiculous. It is extreme. The article further states, there is a world of difference between a 17-year-old girl voluntarily sharing an image of herself with her 18-year-old boyfriend and a 3-year-old being forced into sex acts. Morrow knows that, but she also philosophically opposes mandatory minimum sentences and invented a case to arrive at her conclusion. It's revolting, it's judicial activism, to use the Latin legal term usurpatio legis. She has usurped the law and taken over the legislative function by bending the law to her view. Given that there is no appeal beyond the Supreme Court, Parliament should use the notwithstanding clause in a case like this, but Fraser is saying no. His words, "We don't intend to override the Constitution to fix the problem." This is where Fraser and I disagree. Using the notwithstanding clause to overturn this ruling would not be overriding the Constitution. It would be overturning a bastardization of the plain meaning of the Charter. It would be telling the judge, 5 of them actually, that their job is not to bend the law to their own vision, it is to interpret the law as written. In the immediate term, the federal government should invoke the notwithstanding clause to put these 5 judges in their place. After that, Parliament should look to draft and pass legislation and guidance for the courts to restrict the use of reasonable hypotheticals. This valid tool of the court has seen rapidly escalating abuse over the last decade to the point that we arrive at this decision. Most importantly, Mr. Chair, in Canada's system, Parliament and not the courts are supreme. It's time for a government in Ottawa to act like that is the case to protect our nation's children. And I do want to highlight the comments by Minister of Justice Fraser. We don't intend to override the Constitution. The use of the notwithstanding clause, Section 33, is part of the Charter. There is no overriding here. So it is it's a interpretation that is not worthy of acceptance. Now, I do want to highlight, and I'm going to be wrapping this up very shortly, Mr. Chair, I'm going to highlight some of the language in the dissenting opinion. And I would note that 4 justices were part of the dissenting group that prepared this judgment, and that included the Chief Justice himself, Wagner. And he basically starts off by saying, our case law, meaning the Supreme Court of Canada's case law, is categorical. A mandatory minimum sentence does not necessarily violate Section 12 of the Charter. They say it as follows: the appeal should be allowed. It has not been shown that the minimum sentences provided for in Section 163.1 sub 4 and 4.1 of the Code constitute cruel and unusual punishment within the meaning of Section 12. The impunged provisions are constitutionally valid and operative. The censure of society and the law must be reflected consistently and rigorously in the sentences imposed on offenders who are guilty of sexual offenses against minors. Through the imposition of more severe sentences, the justice system expresses society's deep and rightful indignation. A fit and proportionate sentence is one that is consistent with the teachings of the Supreme Court's decision in Friesen, 2020 SCC 9, and that gives effect to Parliament's intention that sexual offenses against children be punished more heavily. Thank you, Chair.
Thank you. For the benefit of witnesses, when a member makes a motion like this, we do have to suspend regular proceedings. I have no guarantee that we will get back to questioning till 5, so I do ask for your indulgence as we hear the motion. I recognize 3 of the Conservatives that had their hands up first, starting with Mr. Lawton, then Mr. Baber, and then Mr. Gill, followed by Ms. Latanzio.
I am really gobsmacked, Mr. Chair, and quite disappointed that this Conservative motion is necessary. when this Supreme Court decision came down last week, arguing that a mandatory minimum sentence for the possession and acquisition of child sexual abuse and exploitation material was cruel and unusual punishment, I thought this could be and would be a unifying moment for members of Parliament and parliamentarians of all stripes. I actually had a moment of hope that the Liberal government would do the right thing here, say, this is ridiculous, we are going to reintroduce the law at the first available opportunity, and do so using the notwithstanding clause, a key part of the Charter of Rights and Freedoms in this country, to assert that Parliament, as the democratically elected body by Canadians, gets to have the final say on this, and not an activist judge. And I'll speak to why, very briefly, the mandatory minimum is necessary in the first place. The two offenders that were at the center of this Supreme Court ruling had, each of them, hundreds of images of child sexual exploitation and abuse material, referred to in the decision as child pornography. One of them, 90% of the images were depicting young girls between the ages of 3 and 6 years old, some of which showing them being, quote, subjected to acts of penetration and sodomy committed by adults and minors. The other offender as well had hundreds of images and videos of children from 5 to 10, quote, being subjected to sexual abuse such as fellatio and vaginal and anal penetration by adults. Now, the judge at the trial stage gave the first offender the bare minimum, 90 days imprisonment to be served intermittently at his convenience, and 9 months of imprisonment. The second offender was given very similar, in fact, identical sentence there. Without a mandatory minimum, that sentence, which is already in and of itself offensively low, may have been even lower. That is why a mandatory minimum sentence is necessary. And that is why we are calling on this House to reintroduce this legislation with the notwithstanding clause. I was a victim of sexual abuse as a child. And to my knowledge, there are no photos or videos of that. And I hope that that will end up being true. Child sexual exploitation and abuse material does not exist on a computer screen with the person who possesses it only. There are victims, hundreds of victims of this. There is a market for this. The government needs to send the strictest possible penalty, the strongest possible message in denouncing this. This should not be a partisan issue. This should be something that every member of this committee, Liberal, Bloc, and Conservative, can support, regardless of what the Minister of Justice has said on this, that we call on the House to do the right thing and protect children. Thank you.
Thank you, Roman, and then Amarjeet.
Thank you, Chair. This is not only about kids already abused, raped, and exploited in these pictures and videos. This is about more kids in the future who will be raped because the courts fail to punish these perverts enough and thereby deter future perverts. We gotta go hard on this so we can kill this industry. I used to lecture on the Charter a bit, and I want to talk about the Charter here. What was the point of the notwithstanding clause? It was to prevent absurdity. Attorney General Jean Chrétien used the notwithstanding clause to seal the deal on the Charter. That's how it came about. And he specifically used an example for absurdity that the Supreme Court could come up with. It was a hypothetical. He said, well, for instance, what if the Supreme Court found that possession of child pornography was protected under the freedom of expression? That's the example he used. I think everyone in this room, even the Liberals, would agree that such finding would be absurd. Now, that's not the scenario we have, but it's close. Senneville pled guilty to possession and access to over 300 images of children, mostly girls between ages 3 and 6, being sexually exploited. Nod pled guilty to possession of more than 500 images and more than 250 videos, most of which were children between the ages of 5 and 10 years old, many being raped and sodomized. I'm disgusted by this, colleagues. Striking down the mandatory minimum sentence for each of the 2 counts is exactly the kind of absurdity that the notwithstanding clause was designed to prevent. And I say this as a lawyer in good standing in Ontario. This is crazy. This is precisely why Section 33 was inserted into the Charter. And I'm tired of the use of these hypotheticals every time that the court sees an argument of overbreadth. A first-year law student can come up with a hypothetical which would not make sense and render the law overbroad. You know what happens when there is a crazy scenario like the court considered to strike down the mandatory minimum sentence? There's common sense. The police don't charge. The crowns don't prosecute it. But these guys are monsters. And I'm proud of my colleagues, and I'm proud of the leader of the opposition for clearly saying that we're going to invoke the notwithstanding clause when we're in government to protect these children from these monsters, to prevent this absurdity that the Supreme Court has arrived at. But Attorney General Fraser is refusing to invoke the notwithstanding clause. He knows it's appropriate under the circumstances, but then he would have to be arguing against himself in court after the factum he submitted last month. So I ask my Liberal colleagues on this committee to do your jobs, to safeguard the law, to protect children. Call on this government to invoke the notwithstanding clause, to put these monsters who through their actions contribute to the rape and sodomy of children, to lock them up. Please do the right thing. Thank you, Chair.
Thank you. Mr. Gill.
Thank you, Mr. Chair. Thank you, Mr. Chair. As my colleagues have mentioned, the decision by Supreme Court of Canada to remove mandatory minimum sentence for offences related to child sexual exploitation is absolutely disgusting. The court ruled that a minimum 1-year sentence for these offenders is, quote, cruel and unusual. But what is cruel and unusual are the horrific and damaging acts these offenders committing against children. Child sexual exploitation leaves deep and lasting psychological and emotional wounds that can shape the rest of their lives. As parliamentarians, we have the utmost duty to protect innocent Canadians, especially children. That is why this committee must call on Liberal government to invoke the notwithstanding clause to overturn the Supreme Court's disturbing decision and to reinstate mandatory minimum sentence for child sexual exploitation. The call to use the notwithstanding clause in this case is not a partisan idea. It is supported by leaders from across the political spectrum at both the federal and provincial levels, who agree that protecting children and not offenders must be our priority. With this level of support, this committee must do its part. We must pass this motion and urge the government to act, to make it clear that Canada will always defend our children. Canadians across the country are watching and waiting for Parliament to step up. We hope the government will not stand in the way of the majority of Canadians and will choose to defend our children and not those who exploit them. Thank you, Chair.
Thank you, Mr. Gill. Madame Natanzio.
Mr. Chair, I want to be crystal clear from the onset, every member of this committee shares the same goal, and that is protecting children from exploitation and ensuring that offenders face the toughest possible penalties. There is absolutely no ambiguity on that point. But we also have a duty to act responsibly. The notwithstanding clause is an extraordinary measure that overrides charter rights. It has never been used by a federal government, and it should not be used as a political reaction to a court decision, no matter how strongly we feel about the outcome. Our amendment, there's one amendment to Mr. Brock's motion. Make this motion stronger and more constructive, and I will circulate that to the clerk in a few minutes. The amendment keeps the focus exactly where it belongs, on protecting children without undermining the charter or the independence of our courts. We are calling on the government, this government, to bring forward legislation to strengthen protections against child sexual exploitation. That's the responsible path. Firm action rooted in evidence, respect for the Constitution, and an unwavering commitment to keep our children safe. Because let's be clear, child sexual exploitation is one of the most horrific crimes imaginable. Those who prey on children are the worst of the worst, and they deserve to face the full force of the law. Our government will always stand firm against those who harm any child. And with that, Mr. Chair, I will be sending over the amendment on the third paragraph of Mr. Brock's motion.
Did you want to move the motion? You got to read the motion, I believe.
I've got to read my amendment, and the amendment goes as.
And then you could distribute it, but read it out.
Thank you, Mr. Chair. Is my mic? Now it's off. It's off or it's on?
It's on now.
Okay. So the third paragraph will read as such. The committee call on the government to table legislation to address child sexual exploitation, reaffirming Parliament's unwavering commitment to protecting children and ensuring that offenders face the toughest sentences our justice system allows.
Mr. Health, I thought I saw your hand up. But
I did, but I'll speak to Mr. Latanzo in a minute when it's tabled and people have a copy of it and you're ready.
I will send that to you now.
So I was going to ask for a brief recess so that we can review and consult. And I would like to be acknowledged as the first speaker to Ms. Latanzio's amendment.
Sure, that's fine. Yeah, we'll do that. We'll suspend briefly. You can talk, and let's figure this out, please.
Mr. Elsfather wants to be first.
Okay, so in your inboxes, members, and just I have, for the first round, dismissed the witnesses because we won't
Monsieur
get
le Président, j'ai toujours pas reçu la motion amendée.
Chair, I still have not received the motion. It's on its way. It's on its way, but we're not going to start speaking until we receive it. I want to make sure that we're talking about the same thing. Let me continue out loud, and then you'll be able to continue afterwards. Let me finish, please, and you can judge accordingly.
For this hour, we were not going to get to any questions, unfortunately. You should have in your inboxes both English and French copies of the amendments that Ms. Latanzio has presented. I will read them out loud in both languages, and you can confirm that that is the case in what has been presented to you by email, and then we can continue the debate on this motion, eventually vote on it, and if need be, vote on the main motion. So what Ms. Latanzio has moved in the third paragraph is to replace all the words on the last paragraph after two with the following: table legislation to address child sexual exploitation, reaffirming Parliament's unwavering commitment to protecting children and ensuring that offenders face the toughest sentences our justice system allows. Donc en français, que la motion soit amendée au dernier paragraphe.
And the last paragraph would be amended after the word government. Present legislation to fight against sexual exploitation of children and reaffirming the unflagging engagement of the government to protect children and have the toughest possible penalties against the offenders allowed by our legal system.
Amended motion, Mr. Housefather, and then Mr. Brock. Anthony.
Thank you very much, Mr. Chair. I think on this one, there's a lot that we all agree on. That the, oh, okay.
Mr. Chair, I respect the spirit by which Ms. Latanzio sought an amendment. Unfortunately, it is not it's anywhere close to the spirit and the intent of our particular motion. In fact, it's a whole new motion. In our view, it is out of order and it's not admissible, and we'd be seeking a ruling from the chair accordingly.
Okay.
Mr. Chair?
Yeah.
That's not a point of order.
You want to speak on your point of order? Okay. Just give me a sec to confer with the clerk. We'll continue on this motion while the clerk verifies whether it is admissible. All right, well, that's fine. But let's let Mr. Housefather finish.
I challenge your ruling, so this would not be in order for you to turn to Mr. Housefather. This requires a vote.
Well, I haven't ruled on it yet,
You
so
did.
I would
You
have
did.
to suspend.
Well, you did
No,
by,
I took it under
by
advisement.
turning. Well,
That
I
isn't-
challenge that.
I don't, you can't. So what do you want to do? You want to vote on that, and then I can suspend and confer with the clerk and get back to you on that? Or we can continue while Mr. Housefather.
Let's suspend and confer with the clerk.
Okay, suspend. Okay, we have quorum. After having conferred with the clerk, both motions do in fact deal in principle with the protection of children. So the motion is receivable, and so we can resume debate on the amendment. So you just state what your challenge is.
I challenge your ruling that the Liberal amendment is in order.
Okay, then we will, barring any discussion on it, we will proceed to a vote. All those in favor of Mr. Brock's.
Is there no debate on the point as to whether or not it's within scope or not? Or are we just voting on the fact that
I ruled it within scope. Yeah. So he's challenging the ruling, James. Yeah, so the challenge is formally, shall the chair's ruling be sustained for purposes of this vote? Mr. Maloney, since he's back, will vote, and Mr. Housefather will not. All those in favor say aye. In favor of shall the chair's motion be sustained?
Yes.
Say yes. All those against? Okay, so the motion does carry. We will resume debate on the amendment. Mr. Housefather.
Thank you. Thank you very much, Mr. Chair. Thank you very much, Mr. Chair. I think this is an area where I think we would have a lot of agreement tout à travers le comité. I think
throughout the committee.
Two offenders who were appellants in this case were committed very, very bad crimes, and that they should have very, very strict sentences. And in fact, the Supreme Court's ruling didn't change the sentence of these two offenders, but I would argue that they were too lax, at least one of them. I think we would be able to agree that the minority ruling in this case, or the minority judgment of the four judges that said that the majority should have deferred more to Parliament were correct. But I think we can disagree with the Supreme Court's majority judgment without attacking the Supreme Court as an institution or attacking individual judges on the court and making claims about political motivation being involved in the judgment. What I do think we can work on together is sentencing guidelines. That is something the Justice Committee could focus on. Are the sentencing guidelines incorrect? We could talk about the use of hypotheticals, as Mr. Brock had raised, and whether or not Parliament should be clear about what hypotheticals should be or not be used in the context of such a case. And we certainly could go back, and I think we should go back, and legislate to deal with the court's ruling and to require mandatory minimums in the case of these child sexual offenses that deals with the hypothetical. All we need to do is create a class that excludes the hypothetical, that of the teen sexting that even Mr. Brock agreed he wouldn't have prosecuted. So I think it's a willy-nilly leap to go to the notwithstanding clause, which is something that Parliament has not done since the Charter first came into force. And it sounds like some of the people here would use the notwithstanding clause over and over and over again. And I don't think that's the work that Parliament should do. Parliament should do the work. We don't agree with the majority ruling of the court. We go back, we look at the judgment, and we legislate properly to ensure the strongest possible sentences, but we take into account of that this class was perhaps too wide, and we narrow the class slightly to remove this hypothetical. So anyways, I agree with Ms. Lattanzio's position that we don't need to use the notwithstanding clause. We need to legislate and properly address the court's judgment. Thank you.
So I have MP Brock, unless you want to cede your time to Mr. Okay, so Mr. Lawton, and then Mr. Baber, and then Mr. Gill.
Our motion had very specific direction of a statement that this committee would send to the House, and ideally something that the House would concur with and the government would concur with, and that was that we call on the government to invoke the notwithstanding clause to reinstate mandatory minimum sentences for child sexual exploitation. Now, the amendment that we are debating now from Ms. Lattanzio, from the Liberals, is an amendment that changes the call to action quite significantly, that we call on the government to table legislation to address child sexual exploitation. And the reason that is fundamentally different is because that is, with all due respect to Ms. Lattanzio, that is not specific in terms of what we are calling for that will directly respond to and address the Supreme Court ruling that prompted this discussion. And I do go back to the comments I made in my initial intervention on Mr. Brock's motion, which is that the reason that mandatory minimum exists is for cases where, as in the cases that led to the Supreme Court decision, the trial judges give the bare minimum and even then find ways to go even below that for these heinous offenders who had hundreds of images and videos of young children being abused in unspeakable ways. So this amendment cannot be supported because the amendment allows the government to do something, to table some legislation that skirts around the edges of this issue without dealing with the crux of it and what we are trying to actually have an answer for, which is how do we ensure that judges do not have the ability to let people who have engaged in these horrific crimes slide and go without due sentencing. So, this is not something where I believe we can afford to be imprecise in what we're seeking to do. So I will be voting against this amendment. The amendment neutralizes and neuters the very essence of what we're trying to do, which is make a very strong, deliberate, and specific call to action from the government. And I still reiterate my hope that our original motion can be passed with all party support at this committee, because this is something where the health and lives of children can be materially improved by sending a strong message to child abusers, Mr. Chair.
Thank you, Mr. Lawton. Roman.
In response to Ms. Lattanzio, this is not a political reaction that you're watching on this side. This is the responsible reaction. And I'd like to add that under the circumstances, and given the intent of the notwithstanding clause, if it is not to be used to uphold a mandatory minimum sentence against possession of child pornography, then there is no conceivable scenario that I could imagine where it would be appropriate for the Liberal government, or in fact anyone else, to use the notwithstanding clause. This is precisely, as I said in my initial remarks, the type of scenario that the founders, that the framers who agreed on the Charter have contemplated. And I ask again that we don't just think about the kids abused by Centerville and Nod. I ask that we create enough deterrence to prevent and save future kids and to kill this disgusting industry. I will be voting against the Liberal motion to amend.
Thank you. Mr. Gill.
Well, first of all, I would like to say that we agree that we want to stop child abusers no matter where they exist. We want our kids to be safe, our children to be safe. At the same token, I would like to say Ms. Latenzio amendment will not send a strong, specific message to these predators. These child abusers should realize that we are on the side of the children, not on their side. We have to protect our children from these abusers. And I will always say and always stand wherever I'll find a place where we can save our children. That's the right thing to do. This is what we need to do. The amendment that brought forward is not going to address the issue that we are talking today, so I will be voting against this one as well.
Thank you, Mr. Gill. Mr. Brock.
Thank you, Chair. At this time, I'm moving a sub-amendment to the Liberal amendment. It is not in both official languages, but I'd like to read it out. That the amendment be amended by adding the words allows with the following, quote, provided that the government table its legislative response to the Supreme Court ruling before the end of 2025, and that this be reported to the House.
Just have Andrew make it. Have Andrew live. Mr. Lawton.
Thank you, Mr. Chair. I would like to move the sub-amendment to this. Do I need to read it again? Okay. The sub-amendment is as follows. That the amendment be amended by adding after the word allows with the following, provided that the government table its legislative response to this Supreme Court ruling before the end of 2025, and that this be reported to the House.
I move the motion.
Thank you.
Can we suspend?
We'll probably have bells in the interim, so we'll work through that. Because we agreed to resume to the extent possible as soon as 10 minutes after the vote concludes, we'll resume if that's the case. It will allow for the sub-amendment to be translated into French and properly distributed, so it's fortuitous. But let's wait for the bells to ring. And Ms. Lehans, do you have a question, or we will suspend otherwise?
We will suspend.
Yep, and we can chat amongst ourselves.
Please.
Thank you.
Thank you.
I was going to read Mr. Lawton's, do you have a point to make before that, Larry? A point of order? Because I was going to read Mr. Lawton's sub-amendment that everyone's received, and then technically we should proceed. Okay. Yeah. So what you should have in your inboxes, and I will read it out for everyone in both official languages, Mr. Lawton's sub-amendment that reads, so Mr. Lawton has moved the following, that the amendment be amended by adding after the word allows the following, provided that the government table its legislative response to this Supreme Court ruling before the end of 2025, and that this be reported to the House. It'll technically be this motion be reported to the House. Et donc, en français, M. Lawton propose...
And in French, so Mr. Lawton moved that The amendment be amended by adding if the word allows the following, provided that the government table its legislative response to this Supreme Court ruling before the end of 2025 and that this be reported to the House.
Amendment to the amendment, Mr. Brock. Yeah, go ahead.
Mr. Chang wants to be on the list. I see my time. To anyone.
Oh, so you got your teams. Okay.
Yeah.
Mr. Chang? And I had Mr. Chang, and then who else? And Mr. Housefather. And then Mr. Maloney. Okay. Go ahead, Wade.
So, Chair, I want to take a moment to bring this back to what really matters here, the victims, the children who have been exploited, whose innocence was stolen, and whose life will never be the same. We cannot undo their trauma, but we can make sure that those responsible face the full force of law, and that's our duty as Member of Parliament, and that's why this issue demands precision, not politics. I understand the emotion that comes with this. Everyone in this room wants to see the justice done, but justice is not achieved by using tools like now-standing clause that weaken the legal foundation of Canada. It's achieved by writing strong constitutional law that ensure predators are punished every single time. When Parliament legislates carefully, when we write law that balance justice, fairness, and constitutionality, those laws endure, and they don't get struck down. We don't get challenged away. They protect children for good. The government is already moving on this. Legislative work is underway to strengthen protections, close loopholes, and make sure strengthening sentencing provisions reflect the gravity of those crimes. We need to give those the processes the space to happen properly, because getting it wrong would mean that reopening wounds for survivors and creating more uncertainty for victims. So let's be firm. The abuse of children is one of the most despicable acts unimaginable. So every offender should face the toughest sentence possible under Canadian law. But we must do this right. We must do this in a way that respect the Charter, respect judicial independence, and ensure those sentences stand. So this is not about being soft. This is about being smart and being unwavering in our commitment to protecting children through the laws they lost. Thank you, Mr. Speaker. Mr. Chair.
Mr. Chang, I have Mr. Housefather, followed by Ms. Latanzio.
No, Andrew.
Oh, by Ms. Dillon. Apologies. Anthony.
Mr. Chair, can I ask a question procedurally before I speak? Am I allowed to move a sub-amendment to the sub-amendment or not?
No, you can't.
I can't.
You can't sub a sub, but it would have to be voted on, and then you could technically reintroduce an amendment to that. In substance and form of what you were currently trying to propose, but that's the way it would work.
I understand. Okay. So my then Mr. Speaker, Mr. Chair, I'm fine with the general verbiage of the sub-amendment, except for the words "and that this be reported to the House." To me, what we should actually be doing is we should be sending a letter to the Minister of Justice, advising him of the committee's recommendation. We can certainly inform the House by sending a note to the Speaker. I'm not sure what the words "that this be reported to the House" actually achieves, but if there's a way to do this, I think the very first step is to advise the Minister of Justice and to talk to the Minister of Justice about what the desire of this committee is. If the committee wishes to make a point, he really should be the focal point of this, because we're asking the government to take action that would be spearheaded by him. So again, I think that we have a situation here where we're broadly in agreement that the offenders committed, a pretty terrible crime, that these two gentlemen really needed to go to prison, The Supreme Court here didn't change their individual sentences, but we might want to work on sentencing going forward and be more specific about that. We might want to work on sentencing and talking about sentencing guidelines. We might want to look at the issue of using hypotheticals and talking to the minister about having Parliament rein in hypotheticals that are used that have really very little relationship to the cases that were before the court. And I think this would be better achieved by a cross-partisan approach to the minister. So I'm not really aware that reporting it to the House makes the difference. I think this should be a letter to the Minister of Justice and Attorney General to ask him to effect the reforms that the committee is asking him to do and to work with us on more issues, including sentencing guidelines and including the issue of the use of hypotheticals. So I don't support the crafting of this sub-amendment, but I would support it if the words "and that this be reported to the House" were replaced with something else or just dropped. And we could agree on whatever that would be. Thank you, Mr. Chair.
Father, Ms. Dillon, followed by Mr. Lawton, and then Mr. Brock.
Thank you so much, Mr. Chair. When we talk about sentencing for child exploitation, we're talking about some of the most serious and horrific crimes imaginable. Every image, every video, every click, it represents a real child being abused. The pain and trauma are lifelong. Our position is simple. These crimes deserve the toughest sentences our justice system allows. Full stop. But the answer cannot be to grab the notwithstanding clause and throw it into play. That's not how responsible government works, and that's not how strong laws are made. The notwithstanding clause was never meant to be a part of it in response to a court decision. It was meant as a constitutional safeguard, an extraordinary measure for extraordinary circumstances. Once we start normalizing it as a political tool, we open the door for any future government to override rights on a whim. And let's be clear, that's not just about legal theory, that's about real people, real rights, and real consequences. If we erode the Charter in one area, we make it easier to erode it anywhere else. Our government's focus is on fixing this properly. We're already doing the work to bring forward legislation that ensures offenders face serious, consistent, and constitutional sentences for crimes involving the sexual exploitation of children. We want laws that hold up, laws that can't be struck down again because they were rushed or politically motivated. We want laws that deliver justice for victims and send a clear message of deterrence that actually sticks. So yes, we agree with the intent behind this motion, but we won't support shortcuts that risk making the problem worse. This is about real solutions, not symbolic gestures. And make no mistake, the government is not standing still on this. Work is already underway to strengthen sentencing provisions and support enforcement efforts. That's how you protect children. That's how you make real change. Thank you.
Thank you, Ms. Dillon. I have Mr. Lawton and then Mr. Brock.
I trust that Mr. Housefather did not mean the word gentleman when he was referring to these people. That's not a slight at Mr. Housefather, but these are despicable dirtbags we're talking about in this ruling. And I think that we need to understand that when we're talking about what's at stake here in this. And the reason that our motion, and in this case our sub-amendment to the amendment to the motion, calls for reporting to the House is because that means something very specific. We believe this is something that needs to be sent to the House. We do not need a committee motion for us to send strongly worded letters to the Minister of Justice or to anyone. We can notify Minister Fraser, we can tell him all we want, but we want there to be an official process here by which this House has to acknowledge what we have agreed on as a committee after this vote. So reporting to the House is not just, put a sticky note in front of the Speaker. It is a very real process by which this issue can be given the consideration it deserves. So no, it would not be satisfactory for us to just agree on a strongly worded letter to the Minister of Justice and then wipe our hands with this and say that we've done our job as a committee. If the government has not yet presented legislation, has not yet told us what is going to be in legislation, has indicated through the debate we've had on this committee that there won't be use of the notwithstanding clause, there likely will not be a mandatory minimum, that is precisely why this motion that we have put forward is the only way to get this issue before the House in the manner it needs to be entertained.
Mr. Brock.
Thank you, Mr. Chair. Given that it is now 6:28 and we have resources to 6:30, we are worlds apart in terms of coming to a reasonable conclusion to these motions and sub-amendments. I'm going to be asking and encourage the chair to suspend until the next meeting, which would be November the 18th.
I think we have Ms. Latanzio that wanted to speak again on.
No, I wanted to move to adjourn.
I think we're in agreement with Mr. Brock.
Yeah.
No, not adjourn, to suspend.
I'm saying to adjourn, Mr. Chair.
Well, I've got my request on the table.
The motion for Mr. Brock is to suspend. It is an immediate vote on that. There's no debate on it.
To suspend to the 18th of November.
And then the subsequent motion will be to adjourn. Yes, on the suspension, all those vote in favor? All those against? Mr. Housefather not voting? No, that's right. Understood. Yep. So the yeas have it. They're suspended. Faut reprendre.